I noticed that there was a fracture of a very, very, very small bone that seemed insignificant because it was such a small bone, but it was actually very significant because it was a fracture. I'm Kristian Krober. I'm an associate at Block-O'Toole & Murphy. Every client comes to us with a story. Every case is unique. Every individual is different. So injuries will, no matter if it's the same injury, it will affect people differently. And so you have to try to differentiate or at least understand what is important to the client. You can only do that by getting to know the client. There are two ways that you can really get to know the client. The first is just to sit down. A lot of times during intake meetings, I will do this, and you try to really get to know the client. Where are they from? Where did they grow up? Where did they go to high school? What did they do for a living? Why did they want to do that? You get to learn what and who a person is just from the first meeting. And then from there, when you have a basic backdrop of who a person is, you can go through the medical records and really try to understand the injury and the full impact of the injury. Knowing who your client is early on in a case, knowing what drives them, helps you to analyze the evidence and put the evidence within a framework that can help you to explain to strangers, to jurors, why the evidence is impactful, why the medical records or the injuries are impactful and significant, and ultimately explain to the jury who it is that you're representing. Your adversary is always going to try to downplay evidence that helps your case. You have somebody who is educated the same way that you've been educated, who's trying to disprove exactly what you're trying to prove. It's your job as the trial lawyer to explain, whether that's through direct examination or cross-examination or opening or summation, why this piece of evidence is important, why this position is corroborated by the evidence. And oftentimes it's not so much what the defendants or the defendant's witnesses say, but it's what they don't say that you can really lean into, especially on cross-examination. What did the defendant's experts not look at that if you were trying to get to the truth of the matter, if you were trying to find out what really happened here, why wouldn't that be emphasized? Why wouldn't that be reviewed? We try to explain to the jury that we're in a search for truth, and you have to use the entire record. You can't just pick and choose evidence, but you have to use the entire record. Function is really important. The function and the purpose of a body part is really important to understand. With that basic backdrop, a jury can understand the significance of an injury. Take an arm or take a shoulder injury. Somebody may say, well, you know, this person had a minimally invasive surgery, there's no scarring, they didn't miss any work, they went to physical therapy for 2 months and they're back at it and they're fine. But has the client suffered any long-term injuries? Is the client still in pain? Was it an injury to a dominant arm or to a non-dominant arm? Are there any activities that the client can no longer do because of that injury? And it becomes much more revealing how the injury impacted them long term, but the devil is in the details, and you really have to unpack what the details are and learn who the client is and understand what it is that they're going through. I was preparing the case for trial, and it was a motor vehicle accident, and while I was going through the records, I noticed that there was a fracture of a very, very, very small bone that seemed insignificant because it was such a small bone, but it was actually very significant because it was a fracture. And under New York law, if you have a fracture, you satisfy a certain injury threshold, and it takes an arrow out of the defendant's quiver, and they can't argue that our client wasn't hurt enough to bring a lawsuit. Even if it's a small bone, a fracture is a fracture. And so this evidence, although it was in the medical records, we pled it before trial, and we were able to completely take out one of the defenses in the defendant's repertoire. Caring too much for a client can certainly cause you to lose sleep, but when you get up to deliver an opening statement or you get up to issue a summation to a jury, I think if you genuinely care about the client, you care about his or her well-being, that comes through You possess and convey a genuineness that you can't convey unless you have walked the journey with the client. It can be very, very taxing on the attorney trying the case, but it is so powerful and so, I would say it's necessary. When you're injured in an accident as a result of somebody else's carelessness, you want to make sure that you're being represented by the very best. You want a lawyer who's going to be relentless, to want someone who's going to be meticulous. You want somebody who's going to be detail-oriented. If you don't have an attorney who can appreciate all of the small details that might differentiate your case from the run-of-the-mill case, then you're not going to get 100% justice. And that's what every client who's been catastrophically injured or who's been injured because of somebody else's negligence deserves.